While everyone was focused on political drama and celebrity news, something massive happened in Washington that barely made the news. A Supreme Court ruling came down that didn't even talk about gun control directly, but legal experts are saying it might be the most significant hit to state assault weapon bans we've ever seen in this country. The Supreme Court made a decision with all 9 justices agreeing, which is pretty rare. This ruling has serious implications for strict gun laws in states like California, Illinois, New York, and Connecticut. People who know constitutional law and support gun rights are calling this a major wake-up call for states that have been pushing heavy restrictions. And here's the interesting part: most mainstream news outlets have barely covered it. This is Rights and Reloads, and we're here to keep you informed about your rights. We answer your questions and make sure important court decisions don't slip by unnoticed. We're going to walk through what the court actually said, how it affects your state, and why this could change gun rights for decades to come. Back in 2021, the government of Mexico did something pretty bold. They sued major American gun companies, including Smith & Wesson, Glock, Colt, and Ruger. Mexico's position was that these manufacturers were basically feeding weapons to the cartels and causing massive violence in their country by letting guns get smuggled over the border. They weren't saying the companies directly broke any laws. Instead, they wanted to hold them liable for what other people did with the guns, meaning the smugglers, dealers, and ultimately the cartel members using these weapons in crimes. They were asking for more than $10 billion in damages. It was basically a long-shot legal move, trying to use American courts to make gun makers pay for violence happening in another country. The case got plenty of international media attention as it moved through lower courts. At first, a district court threw it out, pointing to a 2005 federal law called the Protection of Lawful Commerce and Arms Act, or PLCAA for short. This law was passed by Congress specifically to protect gun manufacturers and sellers from getting sued when someone misuses their products, as long as the original sale was legal. Think of it this way: you couldn't sue for it if someone deliberately drove their car into a crowd of people. Under PLCAA, you can't sue a gun company just because someone committed a crime with their product. But Mexico didn't give up. They appealed, and the case eventually made its way all the way to the Supreme Court. Then in June 2025, something remarkable happened. All 9 justices, both the liberal and conservative ones, agreed completely. They ruled in favor of the gun manufacturers with a 9-0 vote. 9 justices standing together said no, foreign governments can't use our court system to go after American businesses for crimes that other people committed in their own countries. But here's where it gets really interesting, because there was something in that decision that has way bigger implications than most people realized at first. In that unanimous Supreme Court decision, there was one particular sentence that's now getting more attention than the rest of the entire 25-page opinion combined. The case was mainly about whether Mexico could sue American gun manufacturers, but hidden in the text was this incredibly important statement. A lot of people thought Justice Thomas wrote it, but it was actually Justice Elena Kagan who wrote the whole unanimous opinion. Here's what she said. Firearms like the AR-15 are widely legal and commonly owned by law-abiding citizens for lawful purposes. Now that might sound like just a simple statement of fact, but it's way more than that. This is an official finding from the entire United States Supreme Court about the AR-15, which happens to be the exact type of firearm that assault weapon bans target most often. Why does it matter whether something is commonly used? Well, in previous major cases called Heller and Bruin, the court established that the Second Amendment protects people's right to own and use weapons that are commonly used for lawful purposes by responsible citizens. Put another way, the government can't just ban a particular type of weapon because it looks intimidating or because criminals sometimes use it. If that same weapon is also owned by millions of regular Americans who use it for legal things like protecting their homes, self-defense, hunting, or sport shooting, then it's protected. And get this. The National Shooting Sports Foundation reports that as of 2025, there are more than 24.4 million AR-style rifles owned by regular citizens in the United States. That's actually more than the number of Ford F-150 trucks or most other full-size trucks on American roads. So when Justice Kagan wrote that sentence, she wasn't just making a casual observation. She was essentially setting up a constitutional challenge to every single state-level assault weapon ban in the country. What does this actually mean in real terms? It means that lawyers all over the country can now go into courtrooms, point to this Supreme Court ruling, and tell the judge, look, the Supreme Court has already confirmed that these rifles are widely legal and commonly owned. That means they're protected by the Second Amendment. End of discussion. It's really not an exaggeration to say that this one sentence, quietly tucked into a ruling that was supposed to be about cartel violence and manufacturer liability, could end up destroying every assault weapon ban in America. To really understand how powerful that one sentence is, we need to look at two huge Supreme Court cases from the past. The first one is District of Columbia versus Heller from 2008. The second is New York State Rifle and Pistol Association versus Bruin from 2022. In both of these cases, the court established a straightforward but extremely important rule. The government cannot ban firearms that are commonly used by law-abiding citizens for lawful purposes. This legal standard is now the foundation of how Second Amendment rights are protected today. It doesn't matter how scary a gun looks or what politicians say about it. What matters is whether regular people actually own and use it for legal activities. Now let's talk about the actual numbers here. The National Shooting Sports Foundation says that more than 24.4 million AR-style rifles are owned by regular civilians in the United States as of 2025. That's more than most individual car models you see on the roads. People use these rifles for protecting their homes, for competitive shooting, for hunting, and for recreation. These are clearly lawful activities. So when the Supreme Court stated in its ruling that AR-15s are widely legal and commonly owned, it essentially locked in their constitutional protection. Lawyers fighting for gun rights now have the strongest argument they've ever had. If the AR-15 is common and used lawfully, then it cannot be banned. It's that simple. That's exactly why this sentence is being quoted in legal challenges happening all across the country right now, and it's already starting to change the future of assault weapon laws. The impact of the Supreme Court's ruling is already being seen, especially in California, which is basically ground zero for some of the toughest gun laws in America. One of the biggest legal fights right now is a case called Miller versus Bonta. In this case, a federal judge named Roger Benitez struck down California's Assault Weapons Control Act, saying it violates the Constitution. His reasoning was simple. The state can't ban firearms that are commonly used by law-abiding citizens. Does that sound familiar? Now with the Supreme Court's 9-0 ruling explicitly stating that AR-15 rifles are widely legal and commonly owned, the lawyers challenging bans like the one in California are pressing even harder. They're going into courtrooms and making the argument that if the highest court in the entire country recognizes these rifles as lawful and common, how can any individual state say otherwise? It's an incredibly effective legal strategy, like using a constitutional battering ram, and it's already starting to tear down gun bans that have been in place for years. This isn't just happening in California either. It could potentially happen in every state that has similar laws on the books. This isn't some theoretical possibility anymore. The legal battles are happening right now, and the foundations that these state-level bans were built on are starting to crack. As this legal movement gains momentum, the response from judges and politicians who oppose gun rights has gone from simple resistance to what can only be described as a complete meltdown. During the oral arguments in Miller v. Bonta, some Ninth Circuit judges showed shocking levels of confusion and ignorance. One judge kept calling the AR-15 a machine gun, even after being corrected several times. Another judge called it an A-15, apparently unable to even correctly say the name of the rifle he's supposed to be making legal decisions about. Even worse, some judges suggested that constitutional rights might somehow be different depending on which state you're in. They implied that a rifle protected by the Constitution in Texas could somehow be banned in California. That's not just wrong legally, it's a complete misunderstanding of how the Constitution actually works. Imagine if someone said your First Amendment right to free speech changes based on your zip code. That would be ridiculous, right? Yet that's the kind of reasoning being used to try to defend these bans. These reactions aren't just poorly informed, they're desperate. They show a group of judges frantically trying to hold on to laws that are now legally impossible to defend, especially after the Supreme Court clearly stated that AR-15 rifles are common, lawful, and constitutionally protected. The legal landscape is changing, and the people trying to cling to the old way of doing things are running out of arguments. This legal battle isn't just about California. Right now, 10 states plus Washington, D.C. have their own versions of assault weapon bans. They all use similar language to restrict popular rifles, mostly based on how they look, targeting features like pistol grips, adjustable stocks, or flash suppressors. But when you look at the actual numbers, they tell a completely different story. In Illinois, a massive ban that passed in 2023 affects more than 2.4 million legal gun owners. In New York, compliance with something called the SAFE Act is incredibly low. Less than 15% of the firearms affected by the law have actually been registered. In Connecticut, out of an estimated 372,000 rifles that the ban covered, only about 50,000 were ever registered during the time period when it was required. What we're seeing here is a huge gap between what these restrictive gun laws say and what citizens are actually doing. And now, with the Supreme Court's ruling in hand, federal courts are starting to pay attention. Judges can't just ignore the facts anymore. These rifles aren't rare or unusual. They're not some fringe weapon. They're mainstream and they're protected by the Constitution. The tide is turning and the legal system is starting to catch up with reality. So what comes next? It's pretty straightforward. Get ready for a flood of new legal challenges. Lawsuits are already being filed or brought back to life in states like Illinois, New York, Maryland, and New Jersey. All of them are using the Supreme Court's 9-0 ruling as their main constitutional weapon. And these aren't small fringe efforts either. They're being supported by major legal organizations, top lawyers who specialize in Second Amendment cases, and a growing number of federal judges who now have clear guidance from the highest court in the country. This ruling didn't just protect gun manufacturers from lawsuits. It sent a loud and unmistakable message. AR-15 rifles are in common use. They are legal and they are protected by the Constitution. The idea that an individual state can just override that because of political pressure or emotional reactions, that era is coming to an end. Because in the United States of America, your constitutional rights don't disappear when you cross state lines. This wasn't just a legal win. This was a reclamation, a powerful statement from the highest court in the land that the Second Amendment still means exactly what it says. Rifles like the AR-15 aren't fringe weapons. They're mainstream, they're used lawfully, and they're constitutionally protected. At Rights and Reloads, we've always said this is the defining fight of our generation. It's the battle between freedom and increasing government control. And make no mistake about it, this ruling just sparked a fire that's spreading across the entire country. So now it's up to you. Subscribe if you believe your rights aren't something that can be negotiated away. Share this video with someone who needs to hear the real truth, not just media headlines. Drop a comment and tell us what you think. Do you think this is the final chapter for assault weapon bans, or is this just the beginning of something even bigger? Whatever happens, we're not going anywhere. We'll be right here breaking down the news, tracking the court rulings, and standing with responsible gun owners every single step of the way.